All righty. Hello, hello, hello. I started talking and not realizing that my mic was still muted. Hi, everyone. How have you been? So, as you can see, we will be trying some different things camera wise, background wise, and sound wise. I have some new equipment coming in. So, feel free to let me know how things work or don't work. And let me know what you think of, the different locales and different locations, right? So let me start by saying hello to everyone here. How are you? I hope you're doing well. I hope you're having an awesome, awesome Sunday. Today we are back to back, internet allowing. Let me forewarn you, I've been having some internet problems. So, internet allowing, and I hope that right now the stream is going well, right? We will be going back to back. First, as you can see, with the Kyle Rittenhouse trial and discussing that. And then, second, we'll come back and discuss the McMichael Bryan trial, which is the trial of the men who are accused of causing the death of Ahmaud Arbery. So, we are going to be back to back. Hi to K Business Podcast. Let me put a little hello in the chat. And again, as you come on into the room, let me know if you can hear me and see me and how the stream is going, because with the internet issues, I, of course, can't be sure if everything is working as it should. So as you come on into the room, let me know if you can hear and see me well. Now, we're not going to waste any time because, like I said, hopefully we're back to back. So we are going to dive right into it. So as you can see from the title, we are discussing the People v. Kyle Rittenhouse. This topic was actually requested by Chief X. So shout out to Chief X. He hit me up and said, "Hey, can we talk about, Kyle Rittenhouse? Are you going to cover that?" And I thought I should cover that, right? So, hello to Theo as well. So, here we are covering Kyle Rittenhouse. Now, per my usual, I have drummed up a wonderful article that does really, I think, a very succinct job of kind of going over the facts behind the Kyle Rittenhouse case and giving us an understanding of what happened during the trial. Per usual, we're first going to discuss the FACTS, the facts of what occurred, right? And then I will give you the legal analysis and some of the legal background. I'll explain the verdict because I know there's been a lot of hubbub about the verdict, right? And then I'll take some questions, all right? So let me go ahead and queue up the article that I have for you today. Let's give that a moment. And let's hope to goodness that the internet will be nice enough to us to allow us to actually browse this together. Let's just hope. Let's hope. Okay. All right, here we go. Share screen. I always announce when I'm sharing my screen. Why? I don't know. What's up, Nappy Yankee? How are you? All right, window. No, tab. Okay. Here we are. We're here at AP News, right? This is, from what I've seen, a pretty succinct explanation. Well, I shouldn't say explanation. I should say summarization, right? Summary of the Kyle Rittenhouse charges and the trial, because as you know, we are going to get into the explanation. All right. So, Kyle Rittenhouse was charged with first-degree intentional homicide, attempted first-degree intentional homicide, first-degree reckless homicide, first-degree recklessly endangering safety, and first-degree recklessly endangering safety. Okay, so it looks as though he had multiple counts of the reckless endangering and single counts of the intentional and unintentional first-degree homicide. As we now know, he was acquitted on all charges, right? Let me change this. There we go, because I really want the focus to be on the screen so we can all see what is going on. Okay. Hello to Indigo Forever. And yes, as Nappy Yankee says, please like this video, share this video, and subscribe to the channel. Alrighty. Okay, so let's hop back into our article. So Kyle Rittenhouse shot 3 men, killing 2 of them and wounding the third during a protest against police brutality in Kenosha, Wisconsin last year. Rittenhouse argued that he fired in self-defense after the men attacked him. Here's a look at the chart. Oh, you guys know. So if you're an OG on this channel, you're aware of my little doggy named Mac. Mac, come here, boy. Come here. Come here. Come. He's the mascot for the channel, and he couldn't let us have a live without saying hello. Say hi, boy. All right. Okay, let's get back into it. Okay. Here we go. So, count 1. First-degree reckless homicide, use of a dangerous weapon. Now, after we go through this article, we will actually look at the law, right? You know that one thing that we do on this channel that I would say is a bit nuanced from most of your legal commentary, right? Is we actually pull up the law. So don't worry, for now, we're just talking about what's in this article, but we will take a look at the Wisconsin Criminal Code and look at the law behind all of this, okay? Okay, so count 1, first-degree reckless homicide, use of a dangerous weapon. This charge was connected to the death of Joseph Rosenbaum, the first man Rittenhouse shot. Bystander video shows Rosenbaum chasing Rittenhouse through a parking lot and throwing a plastic bag at him. Rittenhouse flees behind a car and Rosenbaum follows. The video introduced at trial showed Rittenhouse wheeling around and firing as Rosenbaum chased him. Richie McGinnis, a reporter who was trailing Rittenhouse, testified that Rosenbaum lunged for Rittenhouse's gun. Reckless homicide differs from intentional homicide in that prosecutors were not alleging that Rittenhouse intended to murder Rosenbaum. Instead, they were alleging that Rittenhouse caused Rosenbaum's death in circumstances showing an utter disregard for human life. Okay, so now let's have a moment. Just from what we are hearing, right? Just from what we're hearing about videos showing Joseph Rosenbaum chasing Kyle Rittenhouse running, right? I think even to the untrained ear, right? You can already hear that you have some snags with prosecution here, right? Because anyone who is allegedly being chased and is running away from someone is going to argue, hey, whatever it is that I did in self-defense. I was running from this person. I was afraid of this person, right? So from the moment that you hear that allegedly Rosenbaum was chasing Rittenhouse and that video shows Rosenbaum chasing Rittenhouse, you already know you have a complication there with being able to prosecute him for his actions, because he is obviously going to argue that he acted in self-defense. Now, here is one connotation I will add to that. Now, common law self-defense is based on a theory of what is called equal force, right? So for every action, there is an equal reaction. That is common law self-defense. So what that means is, if in fact Rosenbaum did chase Rittenhouse and threw a plastic bag at him, right? And Rittenhouse felt threatened and wanted to somehow defend himself, common law self-defense says that Rittenhouse could have punched Rosenbaum, slapped Rosenbaum, pushed him away, or threw something at him, similar to how Rosenbaum allegedly threw something at Rittenhouse, right? So common law self-defense would say that if someone is chasing you and then they throw a plastic bag at you and you shoot them, that's not equal force. You've used more force than would be equal. And because there's no equality in force there, it's not self-defense. But remember, that is common law self-defense. And every state and every courtroom is going to apply the theory of self-defense differently. So as we can see here, it was decided that, common law self-defense didn't necessarily strictly apply, right? Because it was decided that Kyle Rittenhouse was still acting in self-defense, even though at the outset, the force used doesn't necessarily seem equal, right? Hey to Trip C, how's it going? All right, so let's get back into our article. Okay. Now, we see a little video here. I wonder, to be honest with you, I'm not sure. I didn't click the video. So let's see what this is.
You shot him. I didn't cut though. You're okay. You're okay. We gotta keep him alive. Let's talk to him.
This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create.
Kyle shot Joseph Rosenbaum to stop a threat to his person. And I'm glad he shot him, because if Joseph Rosenbaum had got that gun, I don't for a minute believe he wouldn't have used it against somebody else. He was irrational and crazy.
Did you get my eye out?
Around noon, because the lunch is already in order.
So there's something in particular that I want us to have a little chat about, shall we? So we hear the prosecutor say, you cannot claim self-defense against a threat that you create. 300% true, absolutely true. So I want us to have that learning moment, right? You cannot provoke someone, start a conflict, and then say, oh, well, I was defending myself, right? But again, we know that Kyle Rittenhouse was found not guilty. So what that tells us is that according to those who are the fact finders of this trial, the prosecution did not prove that Kyle Rittenhouse provoked or created the threat. That's the bottom line. Because the prosecutor is right. It's not self-defense when you create the threat, but that means that ultimately the prosecution did not prove that Kyle Rittenhouse created the threat. That is why he was found not guilty. Now, let's talk about the difference between what is proven and what is actually true. Let's have a moment. Now, Kyle Rittenhouse, or you know what? Strike that. The prosecution not providing or presenting enough evidence that Kyle Rittenhouse provoked the threat or created the threat does not mean that he did not create the threat. Right? He could have created the threat, yes, but perhaps there just was not enough evidence for the prosecution to use in this trial to prove that Kyle Rittenhouse, in fact, created the threat that existed. That's it. And that is the difference between the court of law and the real world. You can know something until you know something until you know something, right? But if you cannot prove it, it doesn't matter in court. So for example, right, Trip C can know that Forever Lisa is her cousin. She knows that their mothers are sisters and they grew up together and she knows that. But if they're in a court of law and trying to prove their relation to each other, they would have to provide genetic evidence that they're related, right? Same application here. So the prosecution and maybe even some members of the public, they can know that Kyle Rittenhouse supposedly created this threat and he provoked a conflict. And that's how, he ended up having to run from Joseph Rosenbaum. But if there is no evidence of that to be presented in court, it doesn't exist to the court, right? That's just how it works. Okay. All right, so hello to everyone else who is joining us. Hello to Asaru Amunray and everybody else who is joining us now. We are discussing the Kyle Rittenhouse trial. We are starting off with a nice article that gives us a succinct summarization of what occurred, and then we're going to dive into a legal analysis, okay? All right, so I'm going back to our article now. I'll leave myself in the corner, all right? Count 2. First degree of recklessly endangering safety, use of a dangerous weapon. This felony charge was connected to the Rosenbaum shooting. McGinnis told investigators he was in the line of fire when Rittenhouse shot Rosenbaum, okay? The charge would have been punishable by 12 and a half years in prison. The weapons modifier carried an additional 5 years. So this second count was based upon endangering the safety of others with a dangerous weapon. So that this count was based upon Kyle Rittenhouse having the weapon and endangering the safety of others by opening fire, okay? Count 3, first degree recklessly endangering safety. So another one, use of dangerous weapon. Video shows an unknown man leaping at Rittenhouse and trying to kick him, seconds before Anthony Huber moves his skateboard toward him. Rittenhouse appears to fire 2 rounds at the man, but apparently misses as the man runs away. Okay, so yet again, we're hearing that on video, Kyle Rittenhouse is being seen being chased by other people who are present. It's being seen that people were lunging at him. So notice that whenever we hear video, we always hear that it was caught on video that someone else was threatening Kyle Rittenhouse, chasing Kyle Rittenhouse, etc., etc. And remember the difference between what you know and what you can prove. So we are already hearing a theme here of all the video evidence in this case showing Kyle Rittenhouse defending himself, hence the not guilty verdict. Okay. Count 4, first-degree intentional homicide, use of a dangerous weapon. This charge was in Huber's death. The video shows Rittenhouse running down the street after shooting Rosenbaum. Huber leaps at him and swings a skateboard at his head and neck and tries to grab Rittenhouse's gun before Rittenhouse fires. Yet again, the difference between what you know and what you can prove, or even what you think and what you can prove. So remember we talked about common law self-defense, and we said, Joseph Rosenbaum throws a plastic bag at you, you shoot him. Not really. But this incident with Huber is common law self-defense, because we hear that Huber is using this object to actually directly make contact with Rittenhouse, allegedly, right? And also, Huber is allegedly trying to grab Rittenhouse's gun. So now we do have the elements of common law self-defense, which tells you that in almost any court, a self-defense argument would probably prevail here. We have someone reaching for a weapon that is on someone else's person. So usually, as I said, even in the world of common law self-defense, it would be equal force to try to fire that weapon to get that person away from you because they're trying to take the weapon from you. Okay. Now they go into a little brief discussion of what intentional homicide is, and they are succinct and correct, right? Intentional homicide means that the person intended to kill the person that they eventually caused the death of, right? That is intentional homicide. That is correct. They go into second-degree homicide as well, and then they go to count 5, attempted first-degree intentional homicide, use of a dangerous weapon. Now, this was the charge for Rittenhouse shooting Gage Grosskreutz, I hope I said that right, in the arm seconds after he shot Huber. And as Grosskreutz came towards him holding a pistol. Okay, everyone, let's go back to my original statement. So, hello to Houston Bread, open debate. Hello to a bit Tad. I love your handle. Your screen name is so funny. All right. So let me ask everyone, if you've been here from the beginning and you caught my whole spiel on common law self-defense, right? Do you think it is common law self-defense for Rittenhouse to shoot Gage Grosskreutz when Grosskreutz is coming at him with a pistol? And if you're catching this on the replay, what say you? Is that self-defense? Is it self-defense for Rittenhouse to shoot this man as this man is coming towards him with a pistol? If you think it's self-defense and you're in the chat, give me a 1 in the chat. If you don't think it's self-defense and Rittenhouse still intentionally meant to harm Grosskreutz, put a 2 in the chat. And again, if you're catching this on the replay, you're welcome to vote as well. I'll give you a moment. I'll take a water break. Okay, so I see most of us in the chat. Hello to Anthony B. Hello to Thomas Smith. Hello to Indigo Forever. Hello to Venus. Okay, and hello to Open Debate. I think I said hello to you, but if I didn't. So I see mostly everyone in the chat is saying that they do believe that Rittenhouse would meet the elements for common law self-defense. Yes, he would. For the elements of common law self-defense, if someone is coming at you with a weapon and you then take your weapon and shoot that person, you're defending yourself, right? And it looks like the court did pretty much apply common law self-defense here in saying that Kyle Rittenhouse was defending himself against Gage Grosskreutz. Again, I hope I'm not butchering his name, okay? Count 6, possession of a dangerous weapon by a person under the age of 18. Okay, so this is based on Kyle's age and the fact that per his age, according to state law, he was not permitted to have that type of weapon, allegedly, right? But let's get into it. Wisconsin law prohibits minors from possessing firearms except for hunting or when supervised by an adult in target practice or instruction in the proper use of a dangerous weapon. Rittenhouse's attorneys argued that another subsection of the law regarding short-barreled rifles provided grounds for dismissing the charge. Well, we know the charge was dismissed. So it looks like Rittenhouse's attorneys arguing that, in fact, the law was being misapplied and the type of rifle that Rittenhouse had was not an illegal possession. The court found that to be persuasive, right? So what do I mean when I say the court found to be persuasive? Well, what I mean is the court agreed. That's pretty much what I mean, right? And so the insinuation here is that the type of weapon that Kyle Rittenhouse had was allegedly some type of short-barreled rifle, which means that according to the Wisconsin state law, it wasn't actually illegal for him to have that. Let's get back into it. Count 7, failure to comply with an emergency order from state or local government. Okay, so Rittenhouse was charged with being out on the streets after the 8 p.m. curfew imposed by the city of Kenosha, a minor offense that carries a fine of up to $200. The judge dismissed this charge during the trial, saying that prosecution didn't offer enough evidence to prove it. Okay, I'm gonna look at you here so we can chit chat, okay? Remember the theme for today. There is a difference between what you know and what you can prove. So even if prosecution felt that they knew, that they know, that they know, that they think that Kyle Rittenhouse was out past the curfew, that's not enough. They need to prove it, okay? So let's have a quick combo here. I think I've done this in most of my videos about criminal cases, but I'm going to do it every time because it's so important. Let's have a quick talk about the burden of proof. I'm going to put that in the chat. Pardon me if you hear clickety clack, clack, clack. All right. Burden of proof. Burden of proof is a legal term that just means what has to be proven. And in a criminal case, the prosecution has the burden of proof. They have to prove with evidence that whatever it is they are saying the defendant did so beyond a reasonable doubt. And for those of you who don't know, that is a very, very, very high standard. Beyond a reasonable doubt has been explained in many, many different ways, right? But I think the best way I've ever heard of it being explained is this. Beyond a reasonable doubt means the prosecutor has to prove that there is no other practical, reasonable version of events. That's beyond a reasonable doubt. Prosecution has to prove that the way that they are telling the jury it happened is the only way it could have happened. There's nothing else that's realistic, that's practical, that's reasonable that could have actually happened. They have to go beyond all other reasonable scenarios, beyond all other reasonable potential version of events. Very, very, very high standard. Okay. All right. So I'm going to hop in the chat. Hello to Elaine McCurdy. Let's see. I see there's some chat going on about Kyle Rittenhouse and Gage Grosskreutz. It looks like Gage Grosskreutz admitted that he had pointed a gun at Kyle Rittenhouse. I think that's what I'm seeing in the chat, right? Thomas Smith, NYC. Is that what you're saying? That there was actually an admission? Guess we'll see. All right. So Elaine McCurdy says, in other words, whoever counseled Kyle Rittenhouse covered all the bases to make sure that he could beat the charge. We don't know that, right? That would mean that someone, I guess you're insinuating, counseled him before the incident. I mean, we don't know that. We really don't have any evidence that I know of that Kyle was counseled prior to deciding to go and do what it is that he ended up doing, okay? Theo says he was coached very well from listening to his testimony in court. Now, testimony in court is something different. Learning moment, teaching moment. So an attorney is always going to prep their client before testimony. That is not the same as Mr. Rittenhouse speaking to someone before the incident, right? But we're talking about Kyle Rittenhouse being prepped by his attorney. You guys, that's not out of the ordinary. Every attorney who is actually doing their job preps their witnesses. It is the norm for an attorney to meet with their witness before testimony, to explain to their witness how testimony develops, right? What will occur, what will happen, and to also prepare their witness for some of the things that could come up, especially if there are difficult things that are going to come up. So it is the norm for a client, a witness, whomever, to be prepped by their attorney. That's not outside of the norm. All righty. So now that we've seen that article and we've kind of gotten the gist of the charges that Kyle Rittenhouse faced, I want us to actually have a quick little, I guess you could say, social conversation, because before I dive into the law, because I'm actually curious about something, and I've been, wondering if I am missing something. So to my knowledge, the people who were injured and ultimately, succumbed to their injuries because Kyle Rittenhouse opened fire, those people were Caucasian, right? I just want to, and I swear I'm not being sarcastic. I'm really asking. I've given it a Google, and it looks to me like the people who Kyle Rittenhouse shot and they passed away were Caucasian. Now, I'm not sure if all of the victims were Caucasian. So can someone tell me in the chat, were all of Kyle Rittenhouse's shooting victims Caucasian? I'll wait a moment, because I see their names, but I don't see pictures of all of them. Okay, so all of Kyle Rittenhouse's victims were Caucasian. So now here's my social question, right? This is like a societal question that is truly just a question. It is not meant to offend anyone. It is not meant to sway anyone, and it does not contain any opinion. It is simply a question. Being that Kyle Rittenhouse's victims were all Caucasian, why is there this outrage online about Kyle Rittenhouse attacking people of color, or this being some sort of attack on people of color? Because I've literally seen people saying online, for example, Ricky Smiley posted this thing online saying it's open season on us now. We should arm ourselves. Am I missing something? The victims were Caucasian. So why is the societal conversation being had that Black people are in danger or that people of color are in danger? Anyone? Would anyone like to actually come up? I mean, you can put it in the chat, of course, your take on this, your take on why it's being presented that way, because I'm honestly, I'm the meme right now. I don't know why it's being presented that way. Or you can go ahead and come on up. Let me actually put the link. I'm going to put the link to the StreamYard in the chat. If you want to come on up and have a discourse about it, you can do so. But if you just want to put in the chat your feelings, your thoughts on it, I'd love to hear it, because I honestly am trying to work my way through why celebrities are online saying that Black people are under attack when the victims were Caucasian. Okay, so Nappy Yankee says, well, Anthony B says that's how the news framed it. Nappy Yankee says, because those Caucasians were supposedly fighting for Black rights. Okay, so the Caucasian people that were shot were supposedly a part of the BLM protest. So that's why this is being, that's why we get people online saying that Black people are under attack. Let's see. Spot'em Shot'em says, I think people are mad at the hypocrisy because we all know a 17-year-old Black guy would never get away with this. Okay. Now that I understand, but that's not how it's being framed. It's being framed as Black people are under attack, especially, as I said, people like Ricky Smiley, who have a lot of influence, are online saying that, you know, Black people need to arm themselves like it's the purge for people of color. So that's why I'm kind of like, But this statement about people interpreting there to be hypocrisy, that statement is a bit different. And I can see how people would say, you know, this situation or that situation developed differently than the Kyle Rittenhouse situation. I can see that argument, but that's not what I'm seeing online, which is what threw me off some. Trip C's Treehouse says Andrew Coffey shot the SWAT team and got off, so Black people can do it. Ah, interesting. Interesting. I'm going to get right back to that in a second, Trips Treehouse. Let me talk to Venus very quickly. Venus says the narrative at the time was that there were two camps of non-Black people. There were the BLM sympathizers and the property rights camp. Interesting. Okay. Okay. Okay, let me go back to Trip C's statement. Trip C says, as we read, that Andrew Coffey shot a SWAT team or shot at a SWAT team and got away with it. And that because of that, you know, she believes that Black people can do it as well. So here's my follow-up to that. And again, these questions are simply questions. People, if we cannot have conversations, where are we? You know, we got to be able to ask questions. And I'm a very inquisitive person. So trust me, when I ask a question, it's just for critical thinking's sake. It's not to upset anyone, right? And as I said, I don't share my personal opinion on this channel. So my questions are truly questions. So now here's my question. Andrew Coffey, let's frame our conversation there. Okay. So is it possible that there are people of color who have done Kyle Rittenhouse-esque things like Andrew Coffey, and they were acquitted, but that for some reason we don't talk about those things as much because the impact wasn't negative? So there's this human theory that we tend to talk about negative impacts more than we do positive. So my question is it possible that there are people like Andrew Coffey who do Kyle Rittenhouse-esque things, right? And they get acquitted, but we don't really talk about it as much because it doesn't have the negative impact as the instances in which people aren't acquitted or as the instances in which people lose their life? That's my question. Is it possible that we talk about the negative impact more? All right, Elaine McCurdy, all is true. If 2 killed and 1 were injured for protesting for Black rights and they were white, the question is for the BLM or protest again. What would stop someone else to try that and get away with it? Okay, good point. So Elaine McCurdy makes the point of it sets a dangerous precedent, which I think is a good point. It's a good point to say that it's a dangerous precedent to set, that if you want to have some sort of protest, which our country is rooted in protest. I mean, think all the way back to the Boston Tea Party, right? So I think it is an interesting and thought-provoking statement to make that, hey, we live in a country rooted in the power of protest. And perhaps this sets a dangerous precedent that people don't have the right to protest. And that is dangerous. But we have to remember the videos that were shown at this trial, because although, Elaine, you make a beautiful point, Kyle Rittenhouse's case cannot be decided on that point. His case has to be decided on the facts of his case. And as we know, in his case, they had video with people chasing him around and people pulling guns on him. And so really, there wasn't going to be any other outcome other than acquittal in this case. The larger point that you're making, Elaine, is a valid point. But in this case, the evidence didn't support that sort of decision. All right. Spot him, shot him says Andrew Coffey is different because they charged him for the murder of his own girlfriend. The charges are different. But if he shot at a SWAT team, it is an interesting point to make because the larger conversation being had is discourse about people of color and the safety of people of color in this country, right? All right. Nia X says, but were the victims really protesting for BLM though? Or were they just out there rioting? You see, this is something that I wondered, and again, you all can illuminate for me because let me tell you, when it comes to some of these pop culture cases, I am in the trenches of real life, everyday practice. So I'm not necessarily able to closely follow the pop culture cases, right? Because I have actual cases, right? So fill me in. Was there evidence presented that these men were actually a part of the BLM protests? The men who were injured and ended up passing away? Let me know. Let me know. Anthony B says they were not protesting though. Oh, okay. So again, Anthony says they weren't. So correct me if I am right and enlighten Anthony. Correct me if I'm right. Really? Enlighten me and correct Anthony if he is wrong. Were these men actually BLM protesters? Did they protest in the BLM protest? Let me know. In the meantime, I am going to go ahead and pull my Wisconsin criminal code for you, right? So let's go ahead and do that, shall we? So let me know in the chat. Let me know in the chat. Were they actually protesting? Do we know that they were actually protesting? I'm curious. And again, we have to ask ourselves, questions just to get an understanding of what happened. All righty. So I believe I have the Wisconsin law pulled up for you all. I want to make sure that I get to the right section for you. Perfect. Okay. Here we go. All right. So I'm in the chat now, taking a look at everyone who's here. Hello to Miss Kim Savvy. How are you? Let me put a quick little drop in the chat for you all. Because I realized I haven't done that yet. And I got a little message asking me to make sure that you all had that. Sometimes I tend to forget because, I don't like to do too much when it comes to stuff like that. So let me take one moment to pin it so that I don't get another text message asking me why it's not there. All right. Pin comment. I have to do this from my cell phone. Pin. Okay, perfect. All right, so now I'm going to pull up the Wisconsin State Legislature. All right, we're going to really get into it. So let's go share screen. I always announce when I'm sharing my screen. I have no idea why. It's one of my little things that it's like, why are you announcing it? I have no idea. Okay. So teaching moment, learning moment. Here on Empowered Esquire TV, we like to empower you, to arm you with legal knowledge, right? So we tell you where you can find the actual law, not some second-hand, third-hand, fourth-hand, 11th hand interpretation of it, right? So the state of Wisconsin, of course, has their own website where they have their criminal code posted for you to actually read it yourself. So here we are, docs.legis.wisconsin.gov. Listen, when you've been talking for a while, it just it gets, crazy. And here we have Wisconsin State Legislature, and this is their actual statute, right? So I'm going to actually copy and paste this into the chat. If you want a little leisurely reading one of these days and you want to go visit Wisconsin State Legislature and take a look at the law there, right? It may illuminate for you why Kyle Rittenhouse was ultimately acquitted, okay? All right, Miss Kim Savvy says she's visiting from Information Man's show. Well, thank you, Miss Kim Savvy, for the visit. How are you? All right. So here we go. First degree intentional homicide. Okay, this was one of the counts that Kyle Rittenhouse was charged with. Now, it is described and defined as causing the death of another human being with the intent to kill that person. Okay, all righty. So we know what? That to be found guilty of this statute, Kyle Rittenhouse would have had to have intended to kill someone. Not just to get away, not just to get them away from him, right? He would have to intend to kill someone. First degree, intentional. Okay. Mitigating circumstances. All righty. Now for my OGs, we're going to have another little moment because I want to shout out to my OGs. For my OGs, you know what mitigating is, right? And you know what aggravating is. But if you are a newbie, allow me. Mitigating, to make less severe, right? Aggravating, to make worse. So when you see a statute say or says mitigating circumstances, right? When you see a statute reads mitigating circumstances, aggravating circumstances, you know that the mitigating circumstances are things that could make this, this law, this action less severe. Meaning, if you actually did break this law, these things mean that we'll be kinder to you, right? You know that aggravating circumstances mean that this is, the circumstances that if you broke this law, we're not going to be kind to you. This is actually going to make it worse for you. So mitigating, to make less severe, to make better, kind of. Aggravating, to make more severe, to make worse. Okay? All right, let's get back into it. I'll put me at the bottom here. So here's the mitigating circumstances. So the following are affirmative defenses to prosecution under this section, which would mitigate the offense and make it a second degree, right? So it wouldn't go from intending to kill someone first degree to second degree, okay? Adequate provocation. Aha! Okay, everyone. Death was caused under the influence of adequate provocation, okay? Unnecessary defensive force. Death was caused because the actor believed he or she was in an imminent danger of death or great bodily harm, and that the force used was necessary to defend the endangered person. Now, before we even go even further, we got to stop right there, everyone. What did we hear? First, we heard provocation. And we already know that video was played at the trial in which Kyle Rittenhouse was being chased by the victims. They were throwing things at him. Someone took a skateboard and tried to hit him with it. Someone tried to grab his rifle, right? So we're hearing things that the court could view as what? Provocation. Then we're seeing that they also have a mitigating circumstance where they'll mitigate something from first degree to second degree if the person acted in self-defense, but they used too much force. Remember when we talked about common law self-defense? Remember when I said that common law self-defense is using equal force? Well, remember I also told you that each state has their own little caveats to self-defense. So here the state of Wisconsin has added the caveat that, hey, listen, if you violate common law self-defense, by trying to defend yourself, but using too much force, we will still give you the mitigating circumstance and not charge you with first degree. So what they're saying is, if someone is in the state of Wisconsin and somebody comes at them in a threatening way, and they're trying to defend themselves, they're trying to keep themselves safe, and they use too much force, i.e., you throw a plastic bag at me and then I shoot you, the state of Wisconsin will still consider their claim of self-defense. They'll consider it. That's what they're saying. Alrighty, so we have to have a moment. Let me make sure you can see me so we can have this moment. Be respectful to each other in the chat. Be respectful to each other in the chat. Be respectful to everyone in the chat all the time. or you'll get the blocketh. And my blocketh is forever. I will block you and I will not look back. I don't care. I won't miss you. I won't miss you. I don't have a hard time detaching. Be respectful. But if you do get blocked, then we get to play the block song, which I love that song. So, hey, if you want to get blocked, keep it up. Some people are good at getting blocked around here. Okay, let's get back into the statute. Okay, so we looked at intentional homicide, right? We also saw, what do we see? Reckless endangerment. Let me make sure I read it correctly. We saw recklessly endangering safety. So let's check that out. Let's check out endangering safety. Oh, weird. That didn't come up. Let's see if endangering comes up. No. Endanger. Interesting that endangering only comes up once here. Let's see. Okay. Well, there goes reckless homicide. But do they not have to have the reckless endangerment listed here? Let's see. Reckless homicide, which we could go back to that, but I'm curious to see. Well, you know what? Let's stick to the reckless homicide then and go ahead, because the endangerment might be in a different section of the statute. Okay. So here we have the law for the reckless homicide. So you will note that Kyle Rittenhouse was also charged with 1 count of first-degree reckless homicide. Okay, so this is the actual statute. So whoever recklessly causes the death of another human being under circumstances which show utter disregard for human life. Okay, what is that? Because right now that just sounds like a whole bunch of legalese, right? Let's take a second. Like this video, share this video, subscribe to the channel if you are not subscribed. If you're wondering why you should subscribe, it's very simple. You're here, right? You're learning and it's free. And share the video, okay? So now let's go back to explaining the legalese, right? Because there's a whole lot of legalese in that reckless endangerment in that reckless homicide statute. Water break. Hi, Sheba Mooncat. All right. Oh, Anthony B has created a new block song for us. Blocked up, they won't let me out. We might have to start singing that one too. We might have to start singing that one too. Blocked up, let me out. All right. Done with my horrible singing. So, utter disregard for human life. Here's what that means. It means that you may not intend to take a life, right? So it's not that Kyle Rittenhouse wanted to kill someone. That's not the accusation. The accusation with the first-degree reckless homicide is that he knew that he could cause someone's death, right? That is the definition of utter disregard. Utter disregard. It's not when you mean to do something per se, right? But it's when you know that something could happen, but you do what you're doing anyway. So the accusation was Kyle Rittenhouse knew that his actions could cause someone's death, and he chose to do it anyway. That was the accusation behind the first-degree reckless homicide, okay? So listen, I'm going to hop out of the statute here. Hello, everyone. How are we doing? And what I am going to say to everyone who is here right now, thank you for being here. Thank you for watching and supporting the channel. It's always so well appreciated, right? And now with our, 10 minutes or so that we have left in our little hour on the Rittenhouse case, I'm going to take some questions. Any question that you have about this Kyle Rittenhouse trial, drop it in the chat and I'll answer your question and we'll talk about it, right? All right, so Quack 13, you guys, Mac is aggressively drinking water from his bowl right now. And it's so funny to me how intelligent animals are. Like he knows that I'm busy and he's being ignored and it's just an aggressive lapping up. Oh, goodness. Okay. So Quack 13 says the state made the mistake of overcharging. Aha. Let's have that talk, shall we? How about we switch up our view a little bit here? Yeah, I like that. Let's go with that. I'm going to put Quack 13's comment up. Let's have that talk. Now, is it possible that the state could have garnered a conviction had they had charged lesser charges than what they went for, in my humble opinion? This is my opinion. This is my opinion. Okay. Yes. Yes. It is possible that if the state would have went for lesser charges, in my humble opinion, they could have gotten a conviction. Look at the charges that we see here. Here, let me share my screen again for you just so we can look at these charges again. Look. Here we go. Listen, check it out. First degree intentional homicide. Hold on one moment, everyone. Sorry about that, everyone. Had to take a moment, life. Okay. Let's do this. So now the charges: first degree intentional homicide, attempted first degree intentional homicide, first degree reckless homicide, first degree recklessly endangering safety, first degree recklessly endangering safety. Do you all notice anything that all of these charges have in common? Do 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 do. My Jeopardy music is horrible. Do 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 do. Do you notice anything that all of these charges have in common? Whoever gets it right wins the prize. And for those of you who don't know, when you win a chat prize in my chat, you actually do win something. Who can tell me what's all of Trip C's got it? First degree. First degree, which means that all of these charges required what? Intent. Whenever you see first degree, I'm going to put that in the chat for you all. Intent. Whenever you see first degree, it means that to be found guilty, the person has to have intent. That's a very high bar here, right? That means the prosecution had to prove that Kyle Rittenhouse meant to kill the people who passed away. He meant to potentially kill everyone that was there. That is a very high bar. So that is why in answering Quack 13's question, I say yes. With some lesser charges, they could have got a conviction. And in my humble opinion, they were a little bit zealous here because all of these charges require an intent, a culpable state of mind that they were not able to support with evidence. All right. Now, any other questions? Quack 13 says they went for some lessers after the fact. Okay, that's wonderful, but it looks like that didn't work either, right? From what we see and what we understand. Again, any opinion that I give is based off of the information that is in front of us, okay? All righty. Theo says, how do you rate the judge's impartiality during the trial? Now, I heard quite a bit of hubbub about this judge's behavior during the trial. So let me ask you this question, Theo. Do you think that the judge was impartial? And did you observe anything that you felt was concerning? All right. Hello to the Real Hydro PX. How you doing? We're taking our last few minutes to take questions. So anyone who is just joining us, hello, how are you? And if you're catching this on the replay, hello and how are you to you as well. So Theo, we're waiting on you. What do you think? Do you think the judge was impartial? And did you observe anything that you felt was concerning? And hey, anyone else that would like to jump in the chat, what did you all think about the judge? Did you see things in particular that led you to feel that there was some concern about impartiality? For those of you who may not know, a judge is supposed to be impartial, i.e., neutral. Their purpose is supposed to be to just interpret the law and preside over the trial. Let me know. I'm going to take a quick water break. Okay, so I see an interesting question here from Nappy Yankee about jury selection. Nappy Yankee, I think I might blow your mind here. So Nappy Yankee says, what suspect picks out their jury or is in any vicinity of the judge during their murder trial? We're going to break that down. Let's start with the first question. It is not out of the ordinary for defendants to be present during jury selection. It is not out of the ordinary for defendants to speak to their attorneys and give recommendations during jury selection. So, for example, if Kyle Rittenhouse either said to his attorney or flat out told his attorney, I want to strike that juror. I don't want that juror in our jury. And his attorney then uses their strike because each side gets a number of strikes, right? During jury selection, each side can strike a certain number of jurors to ultimately create the final jury. It is not out of the ordinary for a defendant to be present while their jury is being selected. In fact, that happens all the time. And it is not out of the ordinary for a defendant to give recommendations to their attorney or to flat out pretty much make the decision via their attorney, right? Of jurors who should be stricken from the jury pool. Now, him being in the vicinity of the judge during the murder trial, vicinity of the judge, was he sitting right next to him? What was that? Okay. Okay, Quack 13 says at one point he read a statute from federal law and not Wisconsin. There may have been some reason that that law applied, right? So we would need to know for sure that that law did not apply and that he was reading the inappropriate or the wrong law. Theo says it felt like he was a part of the defense team. Okay, so now we're going to have a nice little combo, right? Again, there is knowing and there is being able to prove. There is feeling something and there is being able to prove. Let's use everyone's favorite example. You may feel that your significant other is cheating on you, right? But if you can't prove it, where does that leave you? Okay. So what is it that occurred that makes you feel like the judge was a part of the defense team? Give me some feedback there. Nia says all defendants are a part of the defense team. Oh, of course. But I thought that Theo was saying that the judge was acting like he was a part of the defense team. That's what I thought Theo was saying, Nia. So Theo, if you'd like to clarify for us, is there anything in specific that occurred? Yes. So he was talking about the judge. Yes. Okay. So be sure to let us know, Theo, if there's something in particular that occurred that led you to feel that way, or is it just a vibe that you got? Because listen, I'm not devaluing feeling a vibe and having a feeling, right? But just per the law, what can you actually prove? Okay. All right, Quack 13 is on it tonight. I think people, go on, StreamYard. I think people are confused with the final selection was a lottery from the 18. That's what Wisconsin does. Okay, good point, Quack 13. Every state, now when I talk about striking jurors and jury selection, I have to add this caveat. Thank you for reminding me, Quack 13. Every state does it differently. So it's possible that Wisconsin doesn't even do the process that I just described to you, right? Every state does it differently. Thank you for reminding me of that, Quack 13. So yes, it looks like Wisconsin has their own process by which they do some sort of lottery. That's what Wisconsin does, right? Every state does jury selection differently. So you cannot compare Wisconsin jury selection to, say, jury selection in your home state. Okay. Alrighty, so listen, we are at 9:01. Typically, I'd hang out a bit more, but as you all know, we're back to back today. That's my best Drake. That's the best Drake I can do. Back to back. So I am going to head on out of here and go on over to Ahmaud Arbery, and we're going to have that combo. I'm wondering if I should switch Ahmaud Arbery to tomorrow night. I'm wondering. And I got to tell you why, because I wonder if Ahmaud Arbery really needs more time, than an hour. What do you all think here in the chat? Do you think that I should full steam ahead with Ahmaud Arbery tonight, or push Ahmaud Arbery to tomorrow night so I could give it more than an hour? What do we think? If you think that Ahmaud Arbery, an hour will be just fine, put a 1 in the chat. If you think no, push it until tomorrow and give it some more time, put a 2 in the chat. Okay, I see Nia already voted for more time. Trip C already voted for more time. Okay, so it looks like I'll probably push Ahmaud Arbery to tomorrow. Yeah, tomorrow, right. So we can give it more than an hour, because it just hit me like, you know what? That may take some more time. Oh, and closing arguments are tomorrow. Yes. So we will push Ahmaud Arbery. All right, I see the votes coming in. We will push Ahmaud Arbery to tomorrow then. You all, Mac is so entertaining. I really wish that you could see some of the things that he does. But anywho, since we're pushing Ahmaud Arbery to tomorrow, I'm going to give you all a few more minutes. Is there anything else that you want to discuss on this Kyle Rittenhouse case? Any more questions? Anything at all? Going once? Going twice? Going 3 times? Alrighty, so listen, thank you for joining me for another installment of Empowered Esquire TV, where we empower you with legal knowledge. I hope you feel powerful and amazing, because you are. Like this video or dislike, hey, Miss Algorithm don't care, so neither do we. Share this video if you feel called to, and subscribe, because what? It's free. So why wouldn't you sign up and subscribe to free edification, free knowledge, a free way to understand the law that is literally in every area of your life? Thank you all so much for being here with me this evening. It means so much to know that you have decided to have this conversation with me, and I appreciate you being here. If you're catching this on the replay, hello. How are you? Tell me in the comments below, what do you think about this verdict? I mean, are you comfortable with it? Or you think that they got it wrong? Do you see why he was found not guilty? Does that make sense to you? Or do you still feel that you're missing something? All right. And Nappy Yankee is recommending a block song to us. Keith Murray, Blocka Blocka. I'm going to have to look that up. All righty. Okay, everyone. Mwah, mwah. You have a wonderful Sunday evening. All right. Go forth, prosper, do wonderful Sunday evening things. All right. See you later.